días a todos. Hoy tenemos aquí a un buen amigo de Girona, que es profesor Damiano Canale, catedrático de Filosofía del Derecho en la Università Bocconi, un lugar que es fantástico para ir, investigar, trabajar. He tenido la oportunidad de estar ahí varios años de invitado y lo hemos pasado realmente muy bien, un lugar muy estimulante. Damiano es una persona muy reconocida en el ámbito de la filosofía del derecho. Ha trabajado temas de argumentación, razonamiento jurídico, ha hecho contribuciones muy importantes en diferencialismo jurídico, que es ahí lo primero que leí de Damiano tenía que ver con la differential role semantics a raíz de Coleman y toda esa discusión. Tiene una cantidad de publicaciones en sitios además muy destacados, muy relevantes. De esto normalmente no hablamos demasiado y no será esta la excepción. Pero si tuviera que definir a Damiano, en mi opinión es un teórico del derecho que tiene una profundidad filosófica inusual. Siempre que lo he leído me ha parecido sumamente enriquecedor, y discutir con él en el uno a uno, que también coincidimos en una estancia en Estados Unidos en el año 2009 y tuvimos oportunidad de hacer muchísimos almuerzos casi cotidianos, ir a comer y discutir, y es una fuente de sabiduría. Siempre tiene algún punto, siempre tiene algo, y además tiene una formación previa muy interesante. Tiene máster en ciencia política, tiene lecturas acumuladas, supongo que ya antiguas, no publica sobre esto, pero sobre sociología, y entonces siempre hay una perspectiva, ¿no? Y hay como un conocimiento también de la filosofía continental que también es inusual en nuestro ambiente analítico, ¿no? Es un filósofo completo, en mi opinión. Es un placer que estés aquí, Damiano. Hacía tiempo creo que no venías por Girona, y bueno, nos encanta que estés. Hoy el título de la presentación es What to do when experts disagree on fact finding. No sé si lo va a presentar en inglés directamente, o
creo que
lo
sí.
presentará en inglés, pero entiende perfectamente también en castellano y obviamente en italiano, entonces el debate lo podremos hacer.
Más o menos.
Lo podremos hacer en diversas lenguas el debate. Bueno, la estructura habitual es 40 minutos de presentación, okay. Lo que necesites, eso es un orientativo, media hora, 45 más o menos, y luego el resto del tiempo lo dedicamos al debate. Muchísimas gracias y es tu tiempo.
Thank you. I switched to English, sorry for that, but my Spanish is terrible, so I don't want to bother you with that. Anyway, so thank you so much for the invitation, opportunity to be here. The paper I'd like to discuss with you today is a part of a larger project on the role of expertise in the law. And given your expertise recognized all over the world, I decided to present a part of the work which is connected to a problem, expert disagreements, a problem which is pretty relevant, legal practice, and also in epistemology. Therefore, what I try to do is to connect what legal theory is actually doing in the field of expert disagreements with what social epistemology, and in particular the epistemology of disagreement, is claiming about the problem and the kind of solutions that are put forward by the philosophical reflection on these issues. This is more or less what I try to do. Just one disclaimer, this is an old-fashioned piece of conceptual analysis. No fancy legal theory, no brand new ideas, nothing. Very, very boring thing. No interest at all. Still, I think that trying to reason on a subject like this might be useful. Perhaps. You're gonna tell me if I'm right about that later on. So I get started with the case. It's a pretty known case. It's Suzanne Jones' case. What is the thing here? So Suzanne was a caregiver provider in San Diego, California, in the at the beginning of the 90s, last century, and on June 24, 97, Suzanne called the 911, so the emergency service in San Diego. Why? Because the baby she was carrying was in a trouble. She stopped breathing, and had gone limp, totally limp. Why was so? This is the story that Suzanne told to the officers. And 2 hours earlier, that day, Jasmine had fallen and hit her head on the floor. So Suzanne put Jasmine on a high chair, but Jasmine tipped over and hit the head on the floor. Another thing which is relevant to the story is that Suzanne didn't know that Jasmine had suffered an injury a couple of weeks before that. When she was with her parents, she fell down on the parents' bed and hit the head on the floor as well. And there might be some connection with the injuries, the later injuries. Okay. The thing is that the rescue workers were unable to revive Jasmine, who was declared dead in the hospital later on. Okay. Another thing which is pretty peculiar to the case is the fact that Suzanne was immediately treated as a suspect, and so the room where Suzanne was treated as a crime scene. And in particular, the medical examiners told the officers that Jasmine's injuries were not consistent with Suzanne's story. There was something going wrong there. The story was not reliable at all, up to the point that they claimed that Jasmine should have intentionally abused the child to death. Okay. This is why Suzanne was charged with voluntary manslaughter, and the case was brought to court. Okay, what about the trial? At the trial, the prosecutors argued, this is what the story told by the prosecutor to the jury. Obviously, we are in California, so there is jury as a fact finder and so on. So the prosecutors argued that Suzanne had lost her temper, possibly because she hadn't been paid by the parents of Jasmine, and Jasmine was a very difficult child. She kept crying, yelling all the time. She couldn't keep on with her, and that there is a reason why he had voluntarily killed the child. Okay, that was the story told the prosecutors, and 5 experts was called to provide testimony during the trial. 7 experts, sorry. 5 experts testified for the prosecutor and 2 for the defense. And all the prosecutor experts claim that Jasmine showed the so-called triad of SPS syndrome. You know that. So it is a shaken baby syndrome triad, where there are 3 facts that are symptomatic of this event. So retinal hemorrhaging, bleeding into the eye, subdural hematoma, bleeding in the brain, and brain swelling. Then there was evidence that Jasmine had an impact on a hard object, and the expert claimed that that was diagnostic of Suzanne having deliberately killed Jasmine with a hard object. Okay, so they declared that Suzanne's story, according to which Jasmine had hit the floor because of fell down on the high chair, was unreliable. Another explanation should be fulfilled. Okay. What about the experts of the defense here? They claim that all the evidence available was compatible with Suzanne's story. Still, they didn't claim that Suzanne's story was the explanation of the fact, the issue. One paradoxical thing of the story is that one of the experts of the defense claimed that it was deferral to one of the experts of the prosecutors. Why? Because he was very, very important expert in the field, and we should defer to him, no matter what. Was something a claim he made during the trial. Based on that, Suzanne was convicted and sentenced to life in prison. Okay, this is the story. Why is the story relevant to my talk today? Why? Because it is a case of disagreement in judicial fact findings. Is an example of disagreement, and the problem of disagreement among experts is becoming more and more relevant, I think, in fact finding. This is the apparent thing. One of the reasons why is it so is because, fact finders, judges, or the jury lack the expertise to evaluate whether how to address the conflict, how to solve the conflicts. And they do not have the knowledge sufficient to address problems like this. So my question in the paper are as follows. So what is the epistemic significance of expert disagreement in reasoning about evidence? What should we do? When we face a disagreement between experts, what does it mean in terms of, within the fact-finding process? Is one thing. And second, what should the judges and jurors do when experts disagree? What should we do? How should we react to that? Okay. To answer these questions, I propose two moves, so to say, from a theoretical point of view. The first one is a kind of conceptual analysis. As a matter of fact, it seems to me that expert disagreements are of various sorts. There are different ways of disagree on different subjects of disagreements, and depending on the subject of disagreement, a different treatment of the disagreement itself is needed. So it's not a good idea to look at expert disagreement as a unique phenomenon. On the contrary, disagreements are of different sorts, and each kind of disagreement needs to be treated differently. This is the first claim I make. In the paper, I try to distinguish between 4 levels, or kinds, as you like, of disagreement. They are connected to one another, but or they might be connected to one another. Not necessarily it is so. Still, I try to have a look at them one by one, so to say. And then we're going to see what they implies in terms of the treatment of disagreement within a trial. So let's start with the first kind of disagreement, explanatory disagreement. Did disagreement frequently come up between the expert appointed by the party, obviously, who might provide alternative explanations of the fact of the case? This is a pretty normal thing, or they are supposed to do so. And these disagreements concern the construction of the facts of the case. A typical case of disagreement of this sort is when expert 1 provides a certain idea whether effect occurred or didn't occur, or explain the causal chain that brought to a certain event in a certain way, and so on. Okay, here is an example which is connected more or less of Suzanne's story. The victim sustained head injury. This is the fact. Explanation of expert 1. Expert 1 claims it was caused by fall, whereas expert 2 claims that it resulted from being struck with a hard object. Okay. This is a pretty common way of disagreeing in fact-finding. What is my take on that? This is a pretty normal thing. It's not problematic at all, judicial fact-finding. because this is a part of, this is connected to the structure of the legal process itself. Okay. Obviously, when faced with disagreement of this sort, the fact finders have to react some way, but this is not a problematic thing in itself. It is within the physiology of the process itself. We need to remember this later on. Okay. So, not be scared by explanatory disagreements. They are a pretty good thing. They can be useful sometimes. Okay. A second sort of disagreement, I call them disagreements about the best evidence, explanation. Evidence, here, the idea is that the disagreement about experts concern the factual reconstruction adopted as an hypothesis by the fact finders, and whether this hypothesis is confirmed during the evaluation of evidence by all available evidence, so the best explanation of evidence. So this is a disagreement which focuses on not on a specific piece of evidence, but on the reconstruction of the case. The Suzanne story, for instance, is this reliable or not? Okay. Obviously, the relevance of this kind of disagreements depends on the standard of proof applying a trial. If the standard is pretty high, think of bar standard, obviously a disagreement of this sort could bring to a specific solution of the case depending on the fact that evidence is considered not sufficient to reach a conclusion of facts. So these are relevant, very relevant kind of disagreements when we have to do, in particular, in criminal law, for instance. Okay. Then we have a third kind of disagreement. Here there is an example, but I'm going to skip it, of disagreement about best explanation. If you want, we can get back to it later on. Then we have theoretical disagreements. These disagreements are a bit different. They are not about facts. They are not about which explanation of the facts is best. Instead, they are about a bigger picture, the generalizations that are used by experts to explain evidence. Okay. They concern the governing laws used to test the hypotheses. Okay. Obviously, in science, theoretical disagreements are pretty common. It is accepted also by legal theory, I would say. The same legal phenomenon can be explained by alternative theories that are commonly accepted or equally accepted by the scientific community. But although they are pretty normal in science, they appear to be problematic in legal proceedings. Why? Because the fact finders lack the epistemic resources, the knowledge to evaluate expert testimony in case of theoretical disagreement. They are not the resources to establish whether a certain explanatory theory is better than another one. Or in many cases, this is the problem they have to face. Okay? Then we have this is a case of an example. If you want, we can get back to it later on. And then there is a fourth kind of disagreement, which is called epistemological disagreement. And this is a disagreement about the standards experts use to decide what counts as good knowledge. It might be a disagreement about what counts as knowledge within the trial. In particular, these standards concern the nature, the sources, or the standards methodologies that are supposed to be used to acquire knowledge as far as the events and the scrutiny are concerned. Okay. Here, I wanted to mention Susanna's comments on this kind of disagreement. She wrote in a couple of papers that there is not, I quote here, there is not a unique rational mode of inference or procedure of inquiry used by all scientists and only by scientists. The idea is we do not have universal or common epistemic standards. They do not exist. Epistemological standards are, in fact, general principles, very general principles that are, explained or accounted for in many different ways, depending on epistemological standpoint that is taken up by scientists. There are some general principles that are usually mentioned when people talk about epistemic standards. Merton list is one of these, universalism, communalism, and in particular, organized skepticism. The idea is that, scientific technical claims are supposed to be subject to inter-subject scrutiny within the scientific community. But, these are very broad claims, very general ideas, very, abstract principles that need to be specified in order to provide some guidance to the people working in scientific area, up to the point that depending on the area you're working in, the standards we are supposed to use are different, or might be pretty different. Okay. And the specialization of science is the driver of the specialization of epistemic standards, so that there are as many kind of sciences as areas where science is kind of subject of what people do. Okay? This seems a little bit paradoxical, but it seems to me to mirror what really is going on right now. And so epistemological standards must be specified based on the area, and it is not surprising that disagreements may pop up because of that, because depending on the way you are going to establish what the standard requires, a different answer is going to come. Okay. So here there is an example, but I skip this. I prefer to discuss with you about that later on. Okay. So what to do when we face disagreements of these sorts? My idea is that the epistemology disagreement could say something about that, could be useful about that. What is the epistemology disagreement? It's a branch of social epistemology that deals with the basic but important question. So, should an expert change their view if another expert disagrees with him? And what is the epistemic significance of this disagreement itself, as far as the amount of knowledge that we have about subjects is concerned? Is the fact that we disagree on certain properties, characteristics, or whatever is going on there in a certain event, says something about what we know about that event or not? This is what actually the epistemology of disagreement is all about. Still, in my opinion, this kind of research could say something interesting also to the lawyers that are dealing with disagreements within legal proceedings. Okay. Even though the perspective is a little bit different. So the perspective we are interested in is not the one of the scientist who is facing a disagreement coming from another scientist, from a peer, but here the standpoint we have to consider is the one of a lay person who doesn't know very, very much about the subject and is supposed to evaluate the epistemic relevance of the disagreement is taking place in front of him or her. Is it clear? So the perspective is a little different. Still, the reflection of the epistemological disagreement can be useful to shed some light on this program as well. So if we look at this discussion, we can identify, it's very simplified picture of the discussion on the subject still. This is what I think is useful to my purpose at least. So there are two main standpoints on the subjects. The so-called equal weight view and the steadfast view. Okay, let's start with the first one. Okay, according to this view, if two equally competent experts disagree. That's important. They are equally competent. No, they are supposed to be so. We should suspend judgment. Why? Because if expert 1 believes that P, expert 2 believes that not P, then the judge, the jurors do not know whether P or not P, as far as what the experts say. Okay. Therefore, they are supposed to suspend their judgment. They don't know what is going on here. Why is it so? Because expert disagreements, the event of the disagreement itself, is evidence. It's a part of the evidence within the prose, and is evidence of what? Is second-order evidence showing that the expert testimony is not reliable. Prima facie, at least. Something more should be done in order to collect real evidence right now. Okay? Well, this position is based on a number of presuppositions, however. Experts are supposed to be equally competent and reliable, first. Second, testimonies have equal epistemic value, same weight. And third, the idea is that if two experts disagree, they cannot be both right. One must be right, and the other one must be wrong. Okay. Richard Feldman argues that when peers disagree, the rational thing to be done, so the rational response to this solution, is that each expert should weaken their beliefs and revise their opinion if this evidence is if the facts are the same and evidence of the facts are supposed to be the same, then an agreement is supposed to be reached. If this is not the case, this is something wrong here. Either I'm not seeing one aspect of the thing that the other aspect is looking at, which is relevant, or I might be mistaken. There is something wrong in what one of the experts is actually doing. Okay? But there is an opposite stance, which is called this steadfast view. Here the idea is that if expert 1 believes that P, expert 2 believes that not P, then they should confirm their conflicting opinions. They should stick on their theory, explanatory theory of effect, for instance. Okay, why is it so? There are a number of presuppositions justifying this kind of attitude by experts, according to this view. First, experts are never equally competent. So it's a kind of ideal picture, the one according to which experts are equally competent. Their expertise depends on the person who collects expertise itself, and depend on the backgrounds, depend on experience, depend on a number of things that cannot be replicated by other people. This is is connected not only to a kind of knowing what, but a knowing how, which is pretty important, in particular in judicial fact-finding. Then, a second reason is that experts are justifying in attributing greater reliability to the tools they are used to. Okay, we have to trust experts. In particular, we have to trust what they are, the standards they use in order to answer a question in fact-finding, and not ask an expert to use theories or frameworks he's not familiar with, because this is a part of the expertise itself. The way in which the expertise is elaborated over time, depending on backgrounds, experience, has an impact on the content of the answer that the expert is going to give. Okay. And then there is another more epistemological reasons that justifies this kind of view, which is the so-called explanatory permissiveness. What is the idea? That there's pretty common sense idea in epistemology that some phenomenon can be explained in many different ways. We know that, and we know that we could have different theories explain the same phenomenon, because each of these theories sheds light on a specific aspect of the phenomenon itself, up to the point that they might be consistent even though they provide different answers to the same questions. What is the reaction to this kind of, should be the reaction to this kind of disagreements according to the steadfast view? Here is a quotation from Elgin. She is a supporter of this view. She said, whether in the face of peer disagreement, to continue to accept that P, to come to accept that not P, or to suspend acceptance about P, is a practical question. It's a practical question. It depends on the question you have to answer. It depends on what you win or what you lose by each answer, and the cost we are going to pay to accept an answer instead of the other. So you are not simply to look at the answer itself from an epistemic point of view, but what the consequences are supposed to be when accepting one answer instead of the other. This is more or less what Elgin proposes about that. So it's a pragmatic question. We have to look at the consequences of the theory. Why is it so? Because both theories are epistemically correct. Okay, that's the idea. Okay, this is more or less so two very important standpoints in the epistemology of disagreement. What can we make of them? How can we, use them in a sense, or what can we draw from them as far as our problem is concerned here? In my view, I think that the fact finders, courts or jury, doesn't mind here, need to strike a balance between two things, two desiderata, I call them. Okay. The first one, I call it the principle of epistemic parsimony. Here I'm moving from a normative standpoint. Okay, I try to answer the question, what should we do? Then we need some normative presuppositions or normative principles to be applying in our reasoning. The first one is a principle of epistemic parsimony, which simply means that we are supposed to recognize the value of expert knowledge. Expert knowledge is something we have to protect. It's a resource. And so here, in particular, when we are facing very, very complex technical issues, expert testimony is very important, is essential. We have to take care of it and to make the best of it in a trial. Okay. And the value of expert knowledge in a trial should not be dismissed only because there is a disagreement taking place there. Okay, we have to find a way out from the disagreement itself. Okay, this is one thing. Another thing, I call it the principle of epistemic non-arbitrariness. Here the idea is that judges should not have the last say as far as the solution of the disagreement is concerned. They should be aware of the fact they don't know what to do. They don't know what to do exactly, and nevertheless, they are supposed to find a way to address the problem. Okay, these are the two principles, and the solution I'm going to propose to you is a kind of balance between these two principles. Okay, this is my proposal. Look, it is apparent that our response to epistemic disagreement within fact-finding depends on the legal system and the rules of the legal system of finding. That's taken for granted. So my proposal is based on a rational reconstruction of the problem itself. We, as rational human beings, are supposed to answer this question in certain ways, that there might be other reasons to adopt the different solution within a legal system. But for a rational, let's try to imagine, from a rational point of view, what the best answer to these problems could be. This is it's a kind of thought experiment I try to provide to you. Okay, which is okay. what should the fact finders do here? Okay, so let's start with explanatory disagreement. In my view, the fact finder should suspend their own evaluation and ask the expert to revise their opinion in order to reach a mutually consistent conclusion. So this is the only rational thing to do. Why? Because if we assume that, the evidence is the same, the theory which explains evidence is the same, and the epistemic standards that are used to elaborate the framework are the same, there is something wrong here. One expert should be right and the other expert should be wrong. If we come to the conclusion that they are both right or both wrong, this is not a kind of explanatory disagreement. It's a disagreement of another sort, because there needs to be something else that makes it the case that they claim something different. Okay, there might be something different in the framework that they are using, or might be something different in the epistemic standards, but not as far as the evidence is concerned. And obviously, there are legal systems where that is possible. For instance, I spent some months in Australia last year. In Australia, we have a system called concurring evidence, where the judge or the jurors are supposed to collect evidence and to have an interplay with the experts where they disagree, and to support the expert in order to reach a common reconstruction of the case, where the disagreement is based on the facts I'm talking about. Okay, when the judge sees that the disagreement is a kind of explanatory disagreement, the procedure allows the judge to ask the expert to revise their views in order to reach a common framework here, explanatory framework. And the same could be said in other legal systems. Obviously, it is not possible at all, or it might be even conceived as something wrong from a legal point of view. I'd like to discuss with you about that later on. The same kind of take can be, defended, so to say, justified when we talk about disagreement about the explanation. Here also, I think that the first standpoint, I call it the equal weight view, should be adopted. So also in this case, a revision of the expert opinion is justified when the theoretical framework is the same and where epistemic values or epistemic principles are the same. Okay, but what about theoretical disagreement? Here the disagreement is not about the facts or evidence, but about the general theories used to explain that. Here, my proposal is the following. If the disagreement is about the covering laws that are equally accepted, there are a number of cases where that happens actually, each expert should stick to their theoretical framework. It makes sense to stick on my point of view and not to change my mind. And the selection of the best explanation should be based on other things and not on the testimony of the expert, on further evidence or on the standard of proof that is used in the evaluation of evidence and so on. Here, the disagreement, from a rational point of view, people who disagree are not supposed to change their mind when general framework is concerned. And finally, what about epistemological disagreement? I think that in cases like this, science should take a step back from courtrooms. So if experts use fundamentally different epistemic standards, that shows that the field itself lacks consensus. There is no standard at all. And the fact finder should assign no probative value to expert testimony. Why? Because this is not science at all. It cannot be used as evidence within the trial. So epistemological disagreement is the only situation where a dismissal of expert evidence is justified from a rational point of view, I think. Okay, this is my proposal, and let's get back to Suzanne Johnson's case, and then I'm done. It seems to me that the court, in the Suzanne Johnson's case, the court was faced with a kind of explanatory disagreement about Presper. We did have different explanations of the fact, and unfortunately, no theoretical disagreements took place at the time. It should have, however. Why? Because some years later, the forensic pediatric pathology came to the conclusion that expert testimony in the case was totally unreliable. You know the story probably that the so-called triad of symptoms is no longer considered to be a diagnostic of abuse at all. Now we know that infants can appear lucid after a head trauma, even though they are going to die in a couple of hours. Now we know that that we need very little force to cause severe injuries in a child. We don't need to hit a child on an object to cause an art injury. And we know that prior injuries can make a certain event worse in terms of the effects. Okay? A thing that was not considered during the trial. So the theory used to explain the facts was simply wrong from a scientific point of view. But no theoretical disagreement took place. Why? Because science was not good science at that time. And it was the reason why Suzanne went to jail for 21 years, okay? But then new evidence popped up at a certain point. It was discovered that the way in which the medical procedure to resuscitate Jasmine was brought about was totally wrong. So they put the machine in the wrong hole, and so they caused the death. It contributed to cause the death of the child instead of trying to save her. And this is why on March 27, 2020, the governor of California granted Suzanne Johnson clemency petition. In this case, the lack of theoretical disagreement was a problem. So theoretical disagreement can be useful sometimes to prevent wrong decisions. Therefore, take care of them. Some of them are useful, some of them are not useful, and we have to treat them differently depending on the kind of disagreement we are looking at. That's all on my part. Thank you. Thank you very much.